Before we begin, a quick and important disclaimer. The following content is intended for educational and entertainment purposes only and does not constitute legal advice, professional counseling, or a formal legal opinion. The historical trends and case studies discussed reflect specific legal environments of the 1980s, which have since evolved significantly. Laws regarding domestic relations, equitable distribution, and community property vary by jurisdiction and are subject to change. Viewers should conduct their own due diligence and consult with the qualified, licensed attorney in their specific state before making any decisions related to family law or asset protection. In 1981, the United States reached a statistical threshold that would forever alter the social and legal fabric of the nation. For the first time in American history, the divorce rate peaked at approximately 5.3 per 1,000 people. This was not just a minor fluctuation in census data. It was a cultural explosion. We were moving out of the experimental, self-actualizing fog of the 1970s and into an era defined by high-stakes litigation, massive wealth accumulation, and the professionalization of the American divorce attorney. If the 1970s were about finding oneself, the 1980s were about keeping what was yours. This decade saw the rise of the celebrity litigator, the birth of complex asset valuation, and a fundamental shift in how the law viewed the American family. By understanding the evolution of the divorce attorney during this pivotal decade, you will gain a deeper insight into how modern property rights are structured, why prenuptial agreements became a staple of the middle class, and how the legal strategies forged in the fire of 1980s excess continue to dictate the potential outcomes of family court cases today. To understand the 1980s divorce attorney, we must first look at the wreckage they were hired to clean up. The 1970s had introduced the concept of no-fault divorce, pioneered by California's Family Law Act of 1969. Before this, an attorney's primary job was to play private investigator. They had to prove grounds, adultery, cruelty, or abandonment. But as the 1980s dawned, the legal landscape shifted from the moral fault of the individual to the economic reality of the partnership. The attorney was no longer just a legal representative. They became a forensic accountant, a high-stakes negotiator, and a media strategist. The 1980s introduced a new type of wealth that the legal system wasn't prepared to handle. We saw the rise of the yuppie, the young urban professional. For the first time, divorce attorneys were dealing with dual-income households where both parties had significant career trajectories, 401k plans, stock options, and professional degrees. This created a massive legal vacuum. How do you value a partner's contribution to a medical degree earned during the marriage? How do you split a pension that hasn't vested yet? These were the questions that defined the 1980s legal battlefield. Consider the landmark case study of O'Brien v. O'Brien in 1985. This New York case changed the game for divorce attorneys nationwide. The court ruled that a professional license, in this case a medical license, was marital property subject to equitable distribution. This meant that the attorney's role expanded into the realm of speculative mathematics. They had to hire expert witnesses to calculate the enhanced earning capacity of a spouse over a 30-year career. If you were a divorce attorney in 1985, you weren't just arguing about who got the station wagon. You were arguing over the net present value of a future neurosurgeon's salary. This led to an era of deep-dive discovery processes that could last years, involving thousands of pages of financial records and depositions that cost tens of thousands of dollars. The 1980s also saw the rise of the super lawyer. Figures like Raoul Felder in New York and Marvin Mitchelson in Los Angeles became household names, often as famous as the celebrities they represented. Mitchelson, in particular, was instrumental in the concept of palimony, following the Marvin versus Marvin case. Although the initial trial happened in the late 70s, the 1980s were the decade where the legal community had to grapple with the fallout. Attorneys began to realize that the contract of a relationship didn't necessarily need a marriage license to be litigated. This forced a massive shift in how attorneys advised their clients. The 1980s attorney became the architect of the modern prenuptial agreement. It was no longer just for the Vanderbilts or the Rockefellers. As the divorce rate hovered near 50%, the attorney's role became prophylactic. They were hired to build walls around assets before the first "I do" was ever whispered. Data from the era shows a staggering increase in legal fees and the length of litigation. In 1980, a standard contested divorce might take 6 months to a year. By 1989, high net worth cases involving equitable distribution could easily drag on for 3 to 5 years. The reason? The 1980s were the decade of the hidden asset. With the deregulation of the financial markets and the rise of offshore banking, attorneys had to become increasingly sophisticated in their search for marital property. This gave birth to the forensic accounting industry. A divorce attorney in 1987 was often managing a team, a private investigator to track lifestyle inconsistencies, a CPA to audit tax returns, and an appraiser to value everything from contemporary art to Beanie Baby collections. This period was also characterized by a significant shift in child custody dynamics. The 1980s moved away from the tender years doctrine, which almost automatically granted custody to the mother. Instead, attorneys began pushing for the best interests of the child standard and the burgeoning concept of joint custody. This added another layer of complexity to the attorney's job. They were no longer just fighting over the bank account, they were litigating parenting schedules and psychological evaluations. The 1980s attorney had to be well-versed in developmental psychology and be able to cross-examine court-appointed experts on the nuances of parental alienation, a term that began to gain traction during this era. Furthermore, the 1980s saw the emergence of the divorce mill versus the boutique firm. As the demand for legal dissolution skyrocketed, the industry bifurcated. On one hand, you had the rise of high-volume, low-cost legal clinics that promised quick processing for the average American. On the other, you had the rise of the high-end boutique firms that charged $500 an hour, a shocking sum for the time, to handle the complexities of the era's new wealth. This period solidified the idea that divorce was not just a legal ending, but a massive economic transfer. The historical trends of the 1980s provide a roadmap for the problems we face today. The strategies developed back then, how to value a business, how to protect intellectual property in a split, and how to navigate the emotional volatility of a high-stakes courtroom, are the foundation of modern family law. By looking back at this decade of excess, we see the blueprint for how the American legal system attempted to put a price tag on love, labor, and the American dream. We are going to examine the specific tactics these attorneys used, the massive mistakes that led to the loss of fortunes, and the step-by-step evolution of the laws that now govern your own assets and family structure. This is not just a history lesson. It is a masterclass in the mechanics of the American legal machine during its most transformative decade. In the following sections, we will break down the specific financial instruments, the psychological warfare of the courtroom, and the legislative shifts that turned the 1980s divorce attorney into the most feared and respected figure in the U.S. legal system. To understand the specific financial instruments, the psychological warfare of the courtroom, and the legislative shifts that turned the 1980s divorce attorney into the most feared and respected figure in the U.S. legal system, we have to look at the transition from the simple to the complex. Before this era, a divorce was largely a matter of dividing tangible property. You had a house, 2 cars, and a savings account. You split them and you moved on. But as the 1980s progressed, the American economy shifted toward a service-oriented, high-finance structure, and the definition of property shifted with it. This forced the divorce attorney to evolve from a mere representative into a specialized financial architect. One of the most significant historical trends during this decade was the widespread adoption of equitable distribution. While community property states like California already had a 50-50 framework, many other states were moving away from title states laws, where whoever held the deed or the title owned the asset. Equitable distribution gave judges and attorneys the power to divide assets based on what was fair, rather than just what was equal. This created a massive opening for legal creativity. An attorney in 1984 wasn't just looking at the bank balance. They were looking at the potential outcomes of the entire marital history. Imagine a character named David in 1986. David is a mid-level executive at a growing tech firm in Massachusetts. He has a base salary, but he also has something that was relatively new to the average American worker: a 401k and unvested stock options. To David, those stock options were a future bonus. To his wife's attorney, they were a present marital asset. This was the era of the valuation revolution. Attorneys had to determine how to value something that might not even exist yet. They began using the Black-Scholes model and other complex financial formulas to put a price tag on David's future success. This wasn't just a legal debate, it was a mathematical war. If an attorney could successfully argue that those options were marital property, they could secure a massive settlement for their client. If they failed to account for them, they could be sued for malpractice. Then came the Retirement Equity Act of 1984, or REA. This federal law was an absolute game-changer for the 1980s divorce attorney. Before REA, if a husband had a pension through his employer, that pension was often considered his personal property, especially if it was a governmental or ERISA-governed plan. Wives who had spent decades out of the workforce raising children were often left with zero retirement security. The REA introduced the Qualified Domestic Relations Order, or QDRO. For the first time, a state court could order a federal or corporate pension plan to pay benefits directly to an ex-spouse. Historical trends show that the 1980s saw a surge in specialized attorneys who did nothing but draft QDROs. The complexity was staggering. If the wording was slightly off, the pension plan administrator would reject the order, and the client would lose their retirement share. This created a new layer of the deep dive discovery process. An attorney would have to subpoena the summary plan description, the individual benefit statement, and the actuarial assumptions of the plan. They had to calculate the coverture fraction, a formula that determined what percentage of the pension was earned during the marriage versus before or after. This was a step-by-step process. Identify the plan, determine the marital portion, value the future stream of income, and draft a legal document that satisfied both state law and federal ERISA guidelines. But it wasn't just about pensions and stocks. The 1980s attorney had to tackle the concept of professional goodwill. Consider the case study of a successful private medical practice in 1987. The tangible assets, the chairs, the X-ray machines, the office supplies, might only be worth $100,000. But the practice was generating $1 million a year in revenue. Attorneys began to argue that the reputation of the doctor was an asset that the spouse helped build by managing the household and supporting the doctor's career. This led to double-dipping controversies that still echo in 2026. Was it fair to value the practice based on its future income, and then also order the doctor to pay alimony from that same income? The 1980s was the decade where these arguments were first refined. Attorneys would hire forensic accountants to perform a capitalization of excess earnings analysis. They would compare the doctor's actual earnings to the average earnings of a similar doctor in the same region. The difference was the excess, which was then capitalized into a present-day value. The environment of the 1980s added another layer of difficulty: high interest rates and inflation. In 1981, the federal funds rate peaked at 20%. Imagine if you were an attorney trying to negotiate a house buyout in that climate. In 2026, we look at 7 or 8% as high, but in the early 80s, the cost of borrowing money was so extreme that the traditional sell the house and split the profit model was often a financial disaster. Attorneys had to become real estate strategists. They developed deferred sale of residence orders. This allowed the custodial parent to stay in the home until the youngest child graduated high school, with the house being sold and the equity split years later. This required the attorney to draft complex clauses regarding who paid the mortgage, who paid for repairs, and how the tax benefits were shared. Furthermore, the 1980s saw the rise of the paper war. This was the decade of the Xerox machine, and attorneys used it to its full potential. A standard discovery request in 1988 could include hundreds of interrogatories, written questions that the other side had to answer under oath, and requests for production that demanded every check stub, credit card receipt, and tax return from the last decade. The goal was often attrition. If you could bury the opposition in paperwork and legal fees, you could force a settlement. This was the scorched earth policy. Attorneys would look for dissipation of marital assets. If a spouse had spent money on a secret apartment, a gambling habit, or expensive gifts for a third party, the attorney would track every cent. They would reconstruct the marital standard of living to argue for higher alimony, showing that the spouse was accustomed to a lifestyle of country clubs, luxury cars, and private schools. This era also redefined the life insurance trust and educational trusts. With the cost of college beginning its meteoric rise, 1980s attorneys began insisting on college contribution clauses. They were no longer just looking at child support until age 18, they were looking at how to fund a Harvard education in 1995. They used the potential outcomes of a child's future to lock in financial commitments years in advance. They used life insurance as a tool to secure support, ensuring that if the payer died, the support wouldn't vanish. Every one of these moves required a deep understanding of tax law, as the Internal Revenue Code underwent massive changes in 1986, affecting how alimony was taxed and how dependents were claimed. As the financial stakes grew, the legal strategies became more aggressive. The 1980s attorney was no longer just a peacemaker, they were a combatant in a war of spreadsheets and statutes. But as the decade progressed, a new and even more volatile element began to take center stage: It wasn't just about who got the money, it was about who got the children. The shift from tender years to best interests opened a door to a psychological battlefield that would change the American family forever. While the financial math was becoming more complex, the psychological warfare was becoming more brutal. The courtroom wasn't just about spreadsheets. It was about the destruction of character. In the next part, we explore the rise of the scorched earth policy, how attorneys used private investigators and psychological evaluations to turn the courtroom into a theater of war, and how the battle for custody became the ultimate leverage in the 1980s divorce. The move from financial spreadsheets to the human psyche represented the most aggressive expansion of the divorce attorney's toolkit in the 1980s. While calculating the present value of a pension was a matter of math, determining the fitness of a parent was a matter of narrative, and in the 1980s, narrative was bought and paid for through two primary channels: private investigators and psychological experts. This was the era of the scorched earth policy, where a legal representative's goal wasn't just to win a share of the assets, but to systematically dismantle the opposing party's credibility in open court. Historical trends show that by the mid-1980s, the private investigation industry saw a nearly 40% increase in domestic surveillance cases. Before the digital footprints we leave in 2026, an attorney couldn't simply subpoena a cloud history or track a GPS location on a smartphone. They had to rely on the physical presence of a PI. Imagine a scenario where a husband, let's call him Robert, is going through a contested divorce in 1984. Robert's attorney doesn't just want to know if his wife is seeing someone else. He wants to know if she is drinking at lunch, if she is leaving the children with a babysitter until 2 a.m., or if she is spending cash from a business that Robert claims is struggling. The PI would spend weeks in a sedan with tinted windows, using high-speed film and long-range lenses to document every movement. This surveillance was expensive, often costing between $500 and $1,000 a day in 1980s currency. The attorney's strategy was to compile a dossier that would be presented during a deposition to induce a panic-driven settlement. If the attorney could produce a photograph of the spouse in a compromising or even just an irresponsible situation, the leverage in child custody and alimony negotiations shifted instantly. The psychological pressure of being followed turned the legal process into a state of constant paranoia for the clients, a tactic that many 1980s attorneys used to shorten the path to a favorable outcome. As the decade progressed, the battle shifted from the streets to the psychiatrist's office. This was the birth of the battle of the experts. With the decline of the tender years doctrine, the old legal presumption that mothers should automatically receive custody of young children, the 1980s courtrooms required a new standard: the best interests of the child. But because best interests was a subjective and vague term, attorneys filled that vacuum with paid psychological evaluations. A divorce attorney in 1987 would rarely walk into a custody hearing without a retained child psychologist or a forensic psychiatrist. Step by step, these evaluations became a standard, grueling part of the litigation process. First, the attorney would move for a court-ordered evaluation. Then, both parents and the children would be subjected to hours of testing, including the MMPI-2, which was refined in 1989, and Rorschach ink blot tests. The attorney's job was to coach their client on how to appear as the stable and primary caregiver, while highlighting the pathology of the other parent. Case studies from this era frequently show attorneys using these evaluations to diagnose an ex-spouse with personality disorders, borderline, narcissistic, or histrionic, to argue that they were unfit for primary physical custody. In 2026, we see the echoes of these tactics in high-conflict custody cases, but the 1980s was the frontier where these weapons were first forged. One of the most controversial tactics was the weaponization of the friendly parent provision. Many states began passing laws that favored the parent who was more likely to encourage a relationship with the other parent. In response, 1980s attorneys developed a paradoxical strategy. They would advise their clients to be overly compliant and friendly in writing and public interactions, while simultaneously filing aggressive motions in court to limit the other parent's time. This created a dual reality where the legal record showed a cooperative parent, but the actual experience of the other spouse was one of systematic exclusion. The financial and psychological aspects of the 1980s divorce were inextricably linked through the concept of custody as a bargaining chip. It was an open secret in the legal community that many fathers or the higher-earning spouse would threaten a full-blown custody battle not because they wanted primary care, but to force the mother to waive her right to alimony or a larger share of the marital home. By 1985, attorneys were effectively using the fear of losing one's children to settle property disputes. If a mother, let's call her Linda, was told that a trial would cost $50,000 and result in a 50-50 chance of losing her kids, she was far more likely to accept a lower monthly support payment. The attorney's role in these high-stakes negotiations was to calculate the breaking point of the opposing party. Furthermore, the 1980s saw the rise of the guardian ad litem, GAL. Originally intended to be a neutral advocate for the child's interests, the GAL often became another player in the attorney's theater of war. A savvy divorce attorney would work to ensure that a GAL who shared their judicial philosophy was appointed to the case. They would flood the GAL with evidence, school records, medical reports, and witness statements from neighbors to shape the recommendation before the case ever reached a judge's desk. This was preventative litigation, where the outcome was decided in the hallways and offices of the courthouse, rather than the courtroom itself. The 1980s attorney also had to navigate the burgeoning awareness of domestic violence and its impact on custody. While the legal system was slow to adapt, attorneys began to realize that allegations of abuse could serve as a silver bullet in a case. This led to a period of intense scrutiny and, unfortunately, the occasional tactical use of such claims. Conversely, attorneys representing victims of abuse in the 1980s faced a monumental task, as they had to overcome a judicial culture that often viewed domestic turmoil as a private family matter rather than a criminal one. They had to pioneer the use of expert testimony on battered woman syndrome to explain why a client might have stayed in a marriage or why they were now terrified of the other parent. As we look back, the 1980s divorce attorney was essentially a director of a very expensive, very painful play. They managed the investigators, the psychologists, the accountants, and the witnesses to create a reality that the judge would find compelling. This was the decade where the win-at-all-costs mentality became the hallmark of the elite family law practitioner. The cost of these battles wasn't just measured in the millions of dollars in legal fees, but in the psychological toll on a generation of children who became the central figures in these high-stakes dramas. However, just as the 1980s attorney was mastering the art of psychological warfare and domestic surveillance, the American economy was about to throw a new curveball. The late 80s brought the era of the corporate divorce, where the assets weren't just houses and cars, but entire companies, intellectual property, and global investments. This required the attorney to step out of the therapist's shadow and into the boardroom. The transition from the family home to the corporate suite changed everything. As the 1980s drew to a close, a new legal frontier emerged that would redefine the divorce attorney's role once again. This was the rise of the mega-divorce, where the legal fees alone could fund a small city. In the next part, we will dive into the high-finance world of the 1980s corporate divorce, exploring how attorneys untangled multi-million-dollar business empires, and why the 1986 Tax Reform Act became the most important piece of paper in a divorce lawyer's briefcase. The 1986 Tax Reform Act, signed into law by Ronald Reagan, was essentially the Big Bang of modern matrimonial law. It didn't just tweak the tax code. It fundamentally rewrote the financial playbook for every divorce attorney in the United States. Before this era, the tax code was a playground of loopholes that savvy attorneys used to subsidize the cost of a divorce. Prior to the mid-80s, the top marginal tax rate was as high as 50%, meaning that for every dollar a high-earning husband paid in alimony, the federal government was effectively paying half of it through tax deductions. This created a powerful incentive for settlement. But when the 1986 Act slashed the top rate to 28%, that government subsidy vanished. Suddenly, a dollar of alimony felt much more expensive, and the 1980s divorce attorney had to become a master of tax-efficient restructuring just to keep their clients from walking away from the negotiating table. One of the most complex historical trends to emerge from this tax shift was the death of the Lester Agreement. Named after a 1961 Supreme Court case, Commissioner versus Lester, these agreements allowed a spouse to bundle alimony and child support into one unallocated payment. Because alimony was tax-deductible for the payer and child support was not, attorneys would call the whole thing alimony. This allowed the higher-earning spouse to write off the entire amount, while the recipient, usually in a much lower tax bracket, paid a smaller amount in taxes. The 1986 Tax Reform Act effectively killed this strategy by introducing the anti-Lester rules, which stated that if any part of a payment was reduced based on a contingency related to a child, such as a child turning 18, that portion was legally child support and therefore not deductible. Step by step, the 1980s attorney had to audit every existing agreement. They had to ensure that alimony payments didn't drop too sharply in the first 3 years, or they would trigger the alimony recapture rules. Imagine a character named Michael in 1987, a high-flying investment banker. If Michael's attorney drafted an agreement where he paid $100,000 in year 1, $80,000 in year 2, and then dropped to $20,000 in year 3, the IRS would look at that and say that the initial high payments were actually a disguised property settlement, not alimony. They would then recapture those deductions, forcing Michael to pay back taxes and interest. To avoid this, attorneys had to use sophisticated calculators and actuarial tables to smooth the payments, a process that added hundreds of billable hours to a case. As the financial stakes grew, the focus shifted from simple tax deductions to the valuation of complex business entities. The 1980s was the decade of the private corporation and the limited partnership. When a business owner got divorced, the attorney's first task was to pierce the corporate veil. They weren't just looking at the salary, they were looking at the perks. In 1988, a divorce attorney would spend weeks subpoenaing general ledgers to find where a business owner had buried personal expenses. Was the company car actually for the business, or was it a gift for a girlfriend? Was the consulting fee paid to the owner's brother a legitimate expense or a way to hide marital income? Consider a case study of a mid-sized construction firm in 1989. The husband, the sole owner, claims the business is worth $500,000 based on its book value, essentially its trucks and equipment. However, the wife's attorney hires a forensic accountant to perform a market approach valuation. They look at what similar firms are selling for in the booming 1980s economy. They argue that the company's goodwill and backlog of contracts make it worth $3 million. This created a massive legal impasse. The attorney's job was to navigate the double-dip trap. If the court valued the business at $3 million based on its future earnings, and then used those same future earnings to calculate a high alimony award for the wife, the husband was being penalized twice for the same dollar. This debate raged through the courts in the late 80s, forcing attorneys to develop the capitalized excess earnings method, which sought to separate the owner's personal efforts from the intrinsic value of the business itself. The 1980s attorney also had to deal with the latent tax liability of assets. Imagine if Michael, our banker, was awarded a stock portfolio worth $5 million, while his wife Susan was awarded the marital home and cash worth $5 million. On paper, it looks like a 50-50 split. But Michael's attorney in 1988 would scream foul. The stock portfolio had a low basis. Michael had bought the stocks years ago for very little. If he sold them to access the cash, he would owe millions in capital gains taxes. Susan's house, meanwhile, had a massive tax exclusion for a primary residence. A 1980s attorney who didn't account for these hidden taxes was committing malpractice. They had to argue for tax affecting the assets, meaning they would discount the value of the stocks by the projected tax hit Michael would take in the future. This required the attorney to be part lawyer, part accountant, and part futurist, predicting what tax rates would look like years down the line. Furthermore, the 1980s saw the rise of the QDRO, for executive compensation. While Part 2 touched on pensions, the corporate divorce of the late 80s involved much more exotic instruments like golden parachutes, non-qualified deferred compensation, and phantom stock options. Attorneys had to figure out if a retention bonus given to a CEO was for work performed during the marriage or as an incentive for future work after the divorce. This led to the time rule or the Hunt formula, where the attorney would create a fraction, the number of months the spouse worked at the company during the marriage over the total number of months required for the bonus to vest. The complexity reached its peak with the 1980s obsession with professional degrees as property. While the O'Brien case in New York was the most famous, attorneys across the country were trying to replicate its success. They would argue that a law degree, an MBA, or even a celebrity's fame was a marital asset. Imagine an attorney in 1989 representing the wife of a rising Hollywood star. They would hire valuation experts to project the actor's lifetime earnings and then demand a percentage of that future income as a property settlement. This was the ultimate evolution of the divorce attorney into a corporate strategist. They were no longer just ending a marriage, they were essentially litigating a merger and acquisition gone wrong. By 1989, the corporate style of divorce had trickled down to the upper middle class. Even a local franchise owner or a successful real estate agent found themselves in a legal process that mirrored a Wall Street takeover. The discovery process became so invasive that it was common for an attorney to demand every credit card slip for a 7-year period. They were looking for dissipation, the legal term for spending marital money on non-marital purposes. In the excess-driven 80s, this often meant tracking down expenditures on luxury travel, jewelry for mistresses, or even the era's rampant drug use. As we move into the final years of the decade, the divorce attorney had successfully transformed the American family court into a high-finance battlefield. But while the attorneys were busy counting the millions, a new crisis was brewing. The very tactics that made these lawyers superstars, the aggression, the invasive discovery, and the astronomical fees, were beginning to draw the ire of the public and the legislature. The era of the scorched earth divorce was about to hit a wall of reform, and a new movement was beginning to whisper a word that many 1980s litigators hated: mediation. The transition from total war to managed peace would define the end of the century, but before we get there, we have to look at the dark side of the 1980s legal boom. In the next part, we explore the divorce-for-profit era, how some firms turned the dissolution of families into a high-volume assembly line, and the shocking ethical scandals that nearly brought the entire industry to its knees. What happened when the pursuit of the best outcome crossed the line into legal extortion? The answer lies in the hidden files of the decade's most notorious firms. The hidden files of the decade's most notorious firms reveal a disturbing pattern of what legal scholars now refer to as churning. Churning is the practice of performing unnecessary legal work specifically to increase the billable hours on a case. In the mid-1980s, this was not just a fringe occurrence. It was a systemic byproduct of the billable hour model that became the industry standard. Before the 1980s, many family law attorneys worked on a flat fee or a more informal arrangement. But as the decade of excess took hold, the law firm was reimagined as a corporate profit center. Associates were given grueling quotas, often required to bill 2,000 to 2,500 hours a year. To meet these targets, the incentive was not to settle cases quickly, but to keep the conflict simmering for as long as possible. Imagine a character named Sarah in 1985. Sarah is a mother of two who has just discovered her husband's infidelity. She walks into a high-rise office in downtown Chicago and meets with a partner at a top-tier firm. She is asked for a $20,000 initial retainer, a massive sum in 1985, equivalent to nearly $60,000 in 2026. The attorney tells her they need to be aggressive to protect her interests. Within 3 weeks, that retainer is gone. How? Through a step-by-step process of procedural bombardment. The attorney spends 5 hours drafting a 30-page complaint full of inflammatory language designed to enrage her husband. Her husband, in turn, hires an equally aggressive attorney who spends 10 hours drafting a motion to strike. Sarah is billed for every phone call, every interoffice conference between the partner and an associate, and every minute the attorney spends waiting in the courthouse hallway. Historical trends show that this era saw the perfection of the 6-minute increment. By billing in tenths of an hour, a 2-minute phone call to say hello could be rounded up to 6 minutes of work at a rate of $300 an hour. If an attorney made 10 such calls a day, they generated an hour of billable time for 20 minutes of actual work. In Sarah's case, the firm used a tactic known as the paper blizzard. They filed dozens of discovery requests, demanding her husband produce every receipt from every business lunch he had attended in the last 5 years. While this was framed as looking for hidden assets, the true outcome was that it forced the husband's legal team to spend weeks billing for the production of documents, which Sarah's team then billed for reviewing. This created a feedback loop of expense where both sets of attorneys were the only certain winners. Case studies from the late 80s highlight even darker ethical breaches. Some firms were found to have a standing policy of never accepting the first 3 settlement offers, regardless of how fair they were. The rationale was that a client who settles in the first month only pays for 1 month of fees. A client who settles after 18 months of litigation pays for a year and a half of billable hours, plus the massive fees associated with trial preparation. This led to the rise of legal extortion. Attorneys would use the threat of embarrassing depositions as a weapon. They would schedule a deposition for the husband's boss, his parents, or his business partners, knowing that the mere threat of such public exposure would force a settlement. But they wouldn't settle until the very last moment, ensuring they had exhausted every possible billable event before the case concluded. This period of divorce for profit was also defined by the lack of transparency in billing. In 1986, the American Bar Association was still grappling with how to regulate the burgeoning industry of high-stakes family law. The 1983 Model Rules of Professional Conduct were supposed to curb these excesses, but they were often toothless in the face of a lawyer's duty to zealously represent their client. If an attorney claimed that a $5,000 psychological evaluation was necessary for the case, few judges had the time or the inclination to second-guess them. This gave attorneys almost total control over the client's finances. In many instances, the legal fees in a 1980s divorce consumed 30 to 40% of the total marital estate, leaving both spouses significantly poorer than when the process began. Another disturbing historical trend was the rise of the sexual predator attorney. Because divorce involves people at their most vulnerable, the power imbalance was extreme. In 1988, several high-profile disciplinary cases came to light involving attorneys who had entered into sexual relationships with their clients or, even more nefariously, offered to trade legal services for sexual favors. The ethical vacuum of the era was so profound that it wasn't until the early 90s that many state bars implemented specific, hardline prohibitions against attorney-client sexual relations in domestic cases. The 1980s was a wild west where the boundaries of professional conduct were constantly tested by the lure of high fees and the lack of oversight. The fallout from these practices began to manifest in the late 1980s through a surge in legal malpractice suits. Clients who had been promised a certain potential outcome and ended up with nothing but debt began to fight back. We saw the first major wave of fee disputes where judges were forced to conduct line-item audits of attorney bills. They found shocking examples of overbilling. Attorneys charging for a full day of trial when the court had adjourned by noon, or billing for 3 attorneys to attend a hearing that only required 1. These case studies served as a wake-up call to the American public, changing the perception of the divorce lawyer from a necessary ally to a predatory figure. Furthermore, the 1980s saw the emergence of the conflict of interest as a tactical weapon. A wealthy spouse would go on a tour of the top 10 divorce attorneys in the city, paying for a 1-hour consultation with each. Under the ethics rules of the time, once that attorney had consulted with one spouse, they were conflicted out of representing the other. This meant that the less wealthy spouse was effectively barred from hiring the best legal talent in the region. This was a calculated move to isolate the opponent, a move that the 1980s attorney not only allowed but often suggested to their clients as a standard opening move. As the decade drew to a close, the industry was at a breaking point. The public was exhausted by the cost and the cruelty of the scorched earth divorce. The courts were clogged with motions that had no legal merit, filed only to drive up fees or harass the opposition. This environmental pressure led to a fundamental shift in the legal philosophy of the United States. The era of the warrior attorney was being challenged by a new breed of professional, who believed that there had to be a better way to end a marriage without destroying the participants. But before this shift could take full effect, the 1980s had one final massive legal evolution to deliver. As wealth became more global and intangible, the divorce attorney had to learn how to hunt for assets across international borders and deep within the new world of digital records. The final years of the 1980s weren't just about billing, they were about the birth of global forensic investigation. In the next part, we will explore the hunt for the hidden millions, how 1980s attorneys pioneered the use of international subpoenas and offshore asset recovery, and the secret bank accounts that would redefine what it meant to have a fair division of property. The stakes were about to go from millions to billions, and the methods used to find that money would forever change the world of international finance. The hunt for international assets in the late 1980s was not merely a legal hurdle. It was a high-stakes intelligence operation that required a divorce attorney to think like a prosecutor and a spy. As the 1980s bull market roared, the American elite began moving capital with unprecedented speed, and the legal system struggled to keep pace. The primary challenge for an attorney in 1988 was the lack of transparency in emerging tax havens. While today in 2026 we have digital ledgers and international data sharing agreements, the 1980s relied on physical ledgers and the impenetrable walls of bank secrecy laws in jurisdictions like Switzerland, the Cayman Islands, and Luxembourg. Step by step, the discovery process for international assets was a grueling exercise in legal friction. It began with the initial lifestyle audit. If a husband, let us call him Jonathan, reported an annual income of $200,000 but was purchasing $5 million villas in the south of France and moving art through galleries in London, a red flag was raised. The divorce attorney would then employ a forensic accountant to perform a net worth analysis. This involved a comprehensive reconstruction of the marital finances over a 10-year period. If the growth in Jonathan's known assets did not match his reported income, the attorney argued that there were undisclosed funds, likely held in offshore entities. One of the most effective historical trends of the era was the use of the shell game. Jonathan might set up a corporation in Delaware, which in turn was owned by a trust in the Cook Islands, which held the shares of a company in Panama that actually owned the bank account. To break this chain, the 1980s attorney had to master the use of letters rogatory. This was a formal request from a United States court to a foreign court, asking for judicial assistance. The process was notoriously slow, often taking 6 months to a year just to get a response. The attorney had to draft the request with extreme specificity, identifying the exact bank and account number, as foreign courts would frequently reject what they called fishing expeditions. Imagine the tactical maneuvering required in 1989. The attorney would first subpoena the travel records of the spouse. In the late 80s, frequent trips to the Caribbean or Zurich were not just vacation markers. They were the breadcrumbs leading to the money. The attorney would then look for wire transfer slips in the thousands of pages of domestic bank records. They were looking for small, structured transactions, a practice known as smuffing, where Jonathan would move money in increments just under the $10,000 federal reporting threshold. By 1989, attorneys were becoming skilled at spotting these patterns and using them to convince a judge to order the spouse to sign a consent directive. The consent directive was a powerful and controversial tool. It was a court order forcing the spouse to sign a document that authorized a foreign bank to release their records to the attorney. If the spouse refused to sign, the attorney would move for a finding of contempt, which could result in jail time or a directed verdict on the financial issues. This was a high-stakes game of chicken. Case studies from this era show that many high-net-worth individuals would rather face a night in a county jail than reveal the true extent of their offshore holdings. However, once the records were obtained, the attorney would find the true potential outcomes of the case were far larger than initially anticipated. The 1980s also saw the rise of the specialized international process server. These individuals were hired to hunt down elusive parties in foreign jurisdictions to serve them with subpoenas. In one notable case study, an attorney representing the wife of a shipping magnate hired a team to track the husband to a yacht in the Mediterranean. The goal was to serve him with a subpoena that would trigger a Mar-Eva injunction, a legal order to freeze assets so they could not be moved or dissipated during the litigation. While American courts were generally more conservative with these freezes than British courts, the 1980s saw an increase in the use of temporary restraining orders on all domestic accounts that had even a tangential link to offshore funds. This global hunt was not just about cash. It was about the commodification of luxury goods as a way to hide wealth. A divorce attorney in 1987 had to become an expert in the valuation of fine art, rare wines, and jewelry. It was common for a spouse to buy $1 million painting by an up-and-coming artist, claim it was a minor decorative piece, and then sell it in London or Paris after the divorce was finalized. The attorney's forensic team had to subpoena auction house records and insurance writers to prove the true value of these portable assets. This was a deep dive into the opaque world of private sales and high-end collectibles. The financial legislation of the late 80s, specifically the 1986 Tax Reform Act, inadvertently aided these investigations. As the IRS increased its scrutiny of offshore holdings, the records generated by tax compliance became a goldmine for divorce lawyers. If Jonathan had filed an FBAR, report of foreign bank and financial accounts, to avoid a tax audit, his wife's attorney could gain access to those disclosures through the discovery process. This was the era where the divorce attorney and the federal government often found themselves as accidental allies in the search for hidden wealth. In 2026, we see the culmination of these 1980s tactics in the form of instantaneous digital traces and blockchain analytics. But the foundation was laid by the lawyers who sat in dusty basements in the 80s, manually cross-referencing credit card slips and telephone logs. The sheer volume of labor required to find the hidden millions was staggering. It was not unusual for a firm to have 3 associates and 2 paralegals dedicated solely to document review for a single case. The cost of the search was often in the hundreds of thousands of dollars, making it a strategy reserved only for the ultra-wealthy. However, the methods used were increasingly sophisticated. Attorneys began using the threat of the IRS to force settlements. They would suggest that if the case went to trial, the evidence of tax evasion, the hidden accounts, would become a matter of public record. Since judges have a duty to report suspected criminal activity, the prospect of a divorce turning into a federal tax prosecution was enough to make even the most stubborn spouse settle for a fair division of property. This was the ultimate leverage. The threat of mutually assured financial destruction. The deep dive into the 1980s offshore hunt reveals a world where the law was constantly chasing the innovation of the financier. Attorneys had to understand the nuances of the Hague Evidence Convention and the difference between a numbered Swiss account and a managed trust in Jersey. They had to navigate the jurisdictional hurdles of the Caribbean, where local governments often protected their banking clients with a zeal that bordered on hostility. This era turned the divorce lawyer into a global strategist, capable of coordinating legal actions across multiple time zones and legal systems. As the hunt for assets crossed continents, the human element of the 1980s divorce was often lost in the spreadsheets. But while the attorneys were tracing wire transfers to the Bahamas, public's fascination was turning toward the people behind the money. The late 80s were about to collide with the rise of the 24-hour news cycle and the tabloidization of the courtroom. The divorce was moving from the private office of a forensic accountant to the front page of the New York Post. The era of the global asset hunt had proven that no matter how far you hid the money, a determined attorney could find it. But what happened when the attorney became as famous as the client? What occurred when the legal strategies themselves were televised for millions of viewers? The transition from the boardroom to the newsroom was about to create a new kind of legal celebrity. In the next part, we explore the rise of the media circus, the era of the televised celebrity divorce, and the attorneys who used the press as a weapon of war. We will look at how the 1980s invented the modern playbook for winning a case in the court of public opinion before ever stepping foot in front of a judge. Winning a case in the court of public opinion before ever stepping foot in front of a judge became the primary objective for the upper echelon of 1980s divorce attorneys. This decade marked the birth of the media-driven litigation strategy, where the primary weapon was not a motion to compel, but a well-timed leak to a tabloid reporter. To understand this shift, we have to look at the environment of the mid-1980s. This was the era when the 24-hour news cycle was in its infancy with CNN, and the tabloid wars between publications like the New York Post and the New York Daily News were at their peak. A divorce attorney in 1986 realized that a judge, while legally bound to the facts, was still a human being who read the papers. If you could paint your client as the victim and the opposing spouse as a villain on the front page of a major metropolitan daily, you had already won half the battle before the first witness was sworn in. Historical trends show that this was the decade of the lawyer as a publicist. Iconic figures like Raoul Felder and Marvin Mitchelson understood that in high-stakes divorces, reputation was an asset just as valuable as a Manhattan penthouse or a fleet of luxury cars. They began to employ PR firms specifically to manage the narrative of a split. The goal was to create a climate of public shame that would force the other side into a quick, quiet, and lucrative settlement. This was the strategy of the tactical leak. Step by step, the process looked like this. First, an attorney would file a complaint filled with the most scandalous, yet technically legal allegations possible: claims of drug use, extreme infidelity, or bizarre domestic habits. Because court filings are public records, the attorney didn't have to call a reporter. They simply had to wait for the courthouse beat writers to find the file. Once the headline hit the stands, the leverage shifted entirely. Consider the case study of the Pulitzer divorce in 1982. This was the ultimate society divorce of the decade, involving Herbert Pulitzer, the heir to the publishing fortune, and his wife Roxanne. The trial in Palm Beach lasted 19 days, featured over 40 witnesses, and became a national obsession. The attorneys on both sides used the media to broadcast allegations that were so salacious they seemed scripted for a soap opera. There were claims of seances, drug-fueled parties, and a diverse array of extramarital affairs. The attorneys understood that by making the trial a public spectacle, they were raising the cost of the divorce for the other party. In the 1980s, the potential outcomes of such a trial weren't just about the division of the estate. They were about whether or not you would ever be invited to a country club or sit on a corporate board again. Imagine a character named Thomas in 1988. Thomas is a high-profile real estate developer in New York who is going through a messy split. His wife's attorney is a master of the media circus. Every time Thomas tries to play hardball in the financial negotiations, a new story appears in the gossip columns about his alleged late-night spending habits or his offshore business dealings. This is the trial by headline. To Thomas, the legal fees of $500 an hour are nothing compared to the millions in potential lost business if his investors start to see him as unstable or unethical. His attorney has to decide whether to fight fire with fire, releasing counter-narratives about the wife's own indiscretions, or to seek a gag order. In the 1980s, however, gag orders were notoriously difficult to enforce and often came too late. The bell had already been rung. The 1980s also saw the perfection of the sidewalk press conference. After a particularly grueling day of testimony or a closed-door deposition, the attorneys would walk out of the courthouse to a forest of microphones. They would give no comment in a way that spoke volumes, or they would provide a succinct 3-sentence soundbite that would lead the 6 o'clock news. This was the era where the divorce lawyer became a celebrity in their own right. They appeared on talk shows like Donahue and Nightline, discussing the state of the American marriage, while subtly signaling to future high-net-worth clients that they were the ones who could handle the heat of the spotlight. A significant historical trend during this period was the use of the prenuptial agreement as a media shield. As we look back from 2026, we see that the 1980s was when prenups moved from being a tool for the ultra-wealthy to a defensive necessity for anyone with a career. One of the most famous examples of this was the divorce of Donald and Ivana Trump, which began at the tail end of the decade. The case was a masterclass in media manipulation. The battle wasn't just over the validity of their 4 separate prenuptial agreements. It was a war for the public sympathy. Every move was calculated for its effect on the Trump brand. Ivana's use of the phrase "don't get mad, get everything" became a cultural touchstone, and the legal maneuvering surrounding their split demonstrated how an attorney could use public opinion to bypass the strict terms of a written contract. The psychological warfare of the media circus had a profound impact on the legal profession itself. It created a tier of glamour attorneys who were expected to be as comfortable on a red carpet as they were in a courtroom. But for the average practitioner, the lesson of the 1980s was clear. The privacy of the marital bedroom was a thing of the past. If you were a divorce attorney in 1989, you had to warn your clients that their tax returns, their credit card statements, and their private diaries were all potential fodder for the evening news. This led to a surge in the use of private judges in arbitration, paying a retired judge to hear the case in a private law office rather than a public courtroom, to avoid the prying eyes of the press. This was the beginning of the 2-tier justice system in family law, where those who could afford it bought their way out of the public spectacle. However, the media circus wasn't just about gossip. It was often used to highlight systemic issues. Attorneys representing the less wealthy spouse would use the press to shine a light on the unfairness of the existing laws, hoping to spark legislative change. They would tell the story of a displaced homemaker who, after 30 years of marriage, was being left with nothing but a small alimony check, while the husband kept the million-dollar business. These narratives were instrumental in the push for more robust, equitable distribution laws and the professionalization of asset valuation. The media, for all its sensationalism, acted as a mirror, showing the American public the often harsh reality of the no-fault era. As we move into the final chapters of this retrospective, the focus on the media and the money begins to reveal a deeper, more troubling cost. While the attorneys were winning the headlines and the accountants were finding the hidden millions, the most vulnerable participants in the 1980s divorce were often left in the shadows. The children of these high-conflict battles were becoming the collateral damage of the win-at-all-costs mentality. This realization led to the next great shift in the legal landscape, a movement toward protecting the psychological well-being of the family, and the rise of a new legal philosophy that would eventually challenge the dominance of the litigator. The 1980s ended with a paradox. The divorce attorney was more powerful, more famous, and more wealthy than ever before, but the system they had built was increasingly viewed as a destructive force. The scorched earth policy was effective for winning settlements, but it left a trail of emotional devastation that the courts were no longer willing to ignore. In the next part, we dive into the psychological toll and the children's rights movement, the era where the legal system finally started to ask not just who gets the money, but what happens to the kids. We will explore the rise of the mandatory parenting class, the evolution of the guardian ad litem, and the secret records of the first generation of children raised in the shadow of the 1980s divorce wars. This shift would fundamentally change how an attorney had to present their case, moving the battle from the headline to the heart. Moving the battle from the headline to the heart meant that by 1988, the divorce attorney's primary focus had shifted from the boardroom and the tabloid page to the child's bedroom. This transition was driven by a growing social realization that the children of the divorce revolution were not just silent witnesses, but were becoming the primary victims of the scorched earth tactics perfected earlier in the decade. Historical trends indicate that the late 1980s saw a massive influx of developmental psychologists and social workers into the courtroom, as judges became increasingly wary of the traditional adversarial model when it came to custody. This era birthed the concept of the child-centric divorce, a legal framework that required attorneys to pivot from being aggressive litigators to being proponents of the best interests of the child. Imagine a character named Jennifer in 1988. Jennifer is 10 years old, and her parents, Susan and Robert, are embroiled in a high-conflict divorce. In 1982, the legal system might have simply looked at which parent was able or which parent had been the primary caregiver. But by 1988, the attorney for Robert is using a new and highly controversial psychological tool called parental alienation syndrome, or PAS. This term, coined by Dr. Richard Gardner in 1985, became the ultimate weapon for 1980s divorce attorneys representing fathers who felt they were being pushed out of their children's lives. The strategy was to argue that Jennifer's sudden refusal to see her father was not a natural reaction to the divorce, but the result of a systematic campaign of brainwashing by Susan. Step by step, the attorney would bring in expert witnesses to testify that Jennifer's language sounded like an adult's, or that she had no ambivalence toward her mother while having total hostility toward her father. This was a psychological deep dive that turned the child's own words into legal evidence, used to discredit the primary caregiver. The use of PAS in the late 1980s was a watershed moment for the American legal system. It forced attorneys to engage with complex psychiatric theories and shifted the burden of proof in custody cases. If an attorney could successfully argue that alienation was occurring, the potential outcomes were drastic. The court could order a change of custody, removing the child from the only home they had ever known to break the alienating bond. Case studies from 1987 and 1989 show that this tactic was often used to counter allegations of domestic abuse or neglect, creating a legal fog where judges struggled to distinguish between a protective parent and an alienating one. This era solidified the role of the forensic psychologist as a permanent fixture in family law, a legacy that continues to influence custody disputes in 2026. Simultaneously, the 1980s saw the legislative rise of joint custody. Before this decade, the tender years doctrine and a general preference for maternal custody dominated the U.S. However, a wave of fathers' rights activism in the mid-80s led to significant statutory changes across the country. Attorneys began pushing for joint legal and physical custody as the default starting point for negotiations. This required a massive shift in how parenting was litigated. Attorneys had to draft incredibly detailed parenting plans, documents that specified everything from who held the child's passport to which parent was responsible for orthodontist appointments. In 1989, a divorce attorney wasn't just arguing about who the child lived with. They were essentially drafting a corporate operating agreement for a family. They had to account for holidays, summer vacations, and the logistical nightmare of the 1980s commuter lifestyle. This era also saw the professionalization of the guardian ad litem, or GAL. While the role had existed in various forms, the late 1980s turned the GAL into a powerful third party in the litigation. A GAL was an attorney or a trained advocate appointed by the court specifically to represent the child's interests. This meant that a 1988 divorce case often involved 3 separate legal teams. One for the husband, one for the wife, and one for the children. The GAL would conduct a deep dive into the family's life, interviewing teachers, pediatricians, and neighbors. For the divorce attorney, managing the GAL became a critical part of the strategy. You didn't just have to convince the judge, you had to convince the GAL, who often held the keys to the final custody recommendation. This added another layer of expense and time to the process, as attorneys billed for hours spent coordinating with the GAL and reviewing their extensive reports. Perhaps the highest stakes for the 1980s divorce attorney involved the 1980 Hague Convention on the civil aspects of international child abduction. Although the treaty was signed in 1980, the United States didn't fully implement it through the International Child Abduction Remedies Act until 1988. This was a direct response to the increasing number of international divorces, where one parent would flee the country with the children to a jurisdiction that didn't recognize U.S. court orders. Imagine an attorney in 1989 dealing with a father who has taken his children to his home country in Europe to avoid a California custody order. The attorney had to navigate a complex web of international law, coordinating with the State Department and Foreign Legal Counsel. The potential outcomes were binary. Either the child was returned immediately to their habitual residence, or they were lost to the other parent forever. This turned the domestic relations lawyer into an international litigator, dealing with treaty interpretations and the jurisdictional sovereignty of foreign nations. Historical trends during this period also highlight the birth of mandatory parenting classes. By the late 80s, several jurisdictions began requiring divorcing parents to attend seminars on the impact of conflict on children. Attorneys initially resisted these requirements, viewing them as an unnecessary hurdle for their clients. However, they quickly realized that a client who excelled in these classes was a more marketable witness in a custody trial. The attorney's role expanded into a form of behavioral coaching, advising clients to avoid disparaging the other parent in front of the children and to document every positive interaction. This was the beginning of the best parent competition, where every weekend outing and school play became a piece of evidence to be presented in court. In the midst of this psychological and legislative complexity, the 1980s attorney was also grappling with the changing definition of a child's needs. The decade saw the first real push for the inclusion of child support for college expenses and the valuation of a child's lifestyle. Attorneys began using specialized software to calculate the cost of raising a child in a high-income household, arguing that the child was entitled to the same standard of living they would have enjoyed had the marriage remained intact. This led to extraordinary child support awards that covered private schools, equestrian lessons, and international travel. The 1980s was the decade where the financial support of children became a mathematical formula, stripping away much of the judicial discretion that had characterized earlier eras. As we look at these developments, it becomes clear that the 1980s divorce attorney was no longer just a legal technician. They had to be a psychologist, a diplomat, and a social engineer. They were operating in a system that was increasingly desperate to protect children, but often lacked the resources to do so effectively. The win-at-all-costs mentality of the early 80s was being tempered by a growing awareness of the long-term emotional damage caused by high-conflict litigation. Yet, the very tools designed to help children, like the GAL and PAS evaluations, often became new weapons in the attorney's arsenal, extending the length and cost of the battles. This era of child-centric litigation brought the profession to a crossroad. The 1980s had started with a focus on individual rights and financial gain, but it was ending with a sobering look at the wreckage of the American family. The attorneys who had become millionaires by fanning the flames of conflict were now facing a world that was starting to value cooperation and mediation. But this transition wasn't clean or easy. The decade ended with a dramatic rise in attorney burnout, ethical scandals, and a public backlash that would lead to a radical restructuring of the family court system in the 90s. But before the 1980s could close, there was one final dark chapter to explore. As the legal fees reached astronomical heights and the emotional toll became unbearable, some attorneys began to cross lines that could never be uncrossed. The pressure to win, combined with the extreme wealth at stake, led to the rise of the dark superlawyer, men and women whose tactics went beyond scorched earth into the realm of the truly illegal. In the next part, we explore the scandals that rocked the 1980s legal elite, the bribes, the wiretaps, and the tragic falls from grace of the decade's most famous practitioners. We will look at how the pursuit of the best outcome led to the ultimate downfall of the 1980s legal icon. The pursuit of the best outcome led to the ultimate downfall of the 1980s legal icon, as the decade of excess reached its ethical breaking point. By 1989, the archetype of the invincible celebrity divorce attorney was cracking under the weight of federal investigations, changing privacy laws, and a growing intolerance for the scorched earth tactics that had defined the era. The most prominent example of this historical trend was the dramatic fall of Marvin Mitchelson, the man who had effectively invented the concept of palimony and represented the biggest names in Hollywood. Mitchelson, who at his peak earned millions and lived a lifestyle that mirrored his clients', found himself the target of the Internal Revenue Service and the California State Bar. His downfall was a case study in how the win-at-all-costs mentality could lead to a total professional collapse. In 1988, the wheels began to come off as allegations of tax evasion and professional misconduct surfaced. By the early 90s, he was sentenced to prison, a victim of the very same aggressive financial scrutiny he had once used against the spouses of his clients. But the fall of individual superstars was only one part of the story. The 1980s saw the emergence of systemic corruption in the family court systems that would eventually lead to some of the largest judicial stings in United States history. In Chicago, the FBI launched Operation Greylord, a massive investigation into judicial bribery and influence peddling. While much of the public focus was on criminal court cases, the investigation revealed a dark underbelly in the domestic relations division. Attorneys were found to be paying kickbacks to judges for favorable rulings on custody, alimony, and asset division. This wasn't just a few rogue actors. It was a culture where the potential outcomes of a case were sometimes dictated by who you knew and how much you were willing to pay. This scandal shattered the public's trust in the family court system and led to the disbarment of dozens of attorneys and the imprisonment of several judges, marking a definitive end to the lawless era of the 1980s courtroom. Step by step, the 1980s attorney also ran into a new legal wall: the modernization of surveillance law. In the early part of the decade, Many attorneys operated in a gray area regarding wiretapping and private recordings. It was a common historical trend for an attorney to advise a client to hide a recording device in the marital bedroom, or to tap the home telephone line to gather evidence of infidelity or hidden assets. However, the Electronic Communications Privacy Act of 1986 significantly tightened federal wiretapping laws. Suddenly, the very evidence an attorney had spent months gathering was not only inadmissible, but could lead to felony charges for both the attorney and the client. Imagine a character named Richard in 1989, a high-stakes litigator who had built his career on being the most aggressive investigator in the city. Richard advises a client to use a voice-activated recorder to catch her husband discussing offshore accounts. Under the new 1986 standards, Richard isn't just winning a case. He is potentially committing a federal crime. This shift forced the industry to move away from the James Bond style of investigation and toward the more sterile, but legal world of forensic accounting. The psychological toll on the attorneys themselves was another factor in the 1980s downfall. This was the decade of the workaholic, where billing 3,000 hours a year was a badge of honor. But the nature of divorce work, dealing with people at their most vitriolic and desperate, led to a surge in substance abuse and mental health crises within the legal profession. Case studies from the late 80s show a staggering increase in the number of family law practitioners entering rehabilitation for cocaine and alcohol addiction. The high-pressure environment, combined with the extreme wealth and the moral ambiguity of the scorched earth policy, created a toxic mix. By 1989, many of the lawyers who had been the lions of the early 80s were either burnt out, disbarred, or facing massive malpractice suits from clients who felt they had been exploited for their fees. One of the most insidious historical trends was the rise of the fee-driven litigation trap. Attorneys would sometimes intentionally delay a case for years, filing motion after motion to ensure their billable hours never dipped. This practice, known as churning, became so prevalent that it led to the 1983 revision of the Federal Rules of Civil Procedure, specifically Rule 11, which was designed to penalize attorneys for filing frivolous or harassing motions. While the rule was meant to streamline the courts, it became a new weapon for 1980s attorneys to use against each other. They would file Rule 11 motions against their opponents, leading to mini trials within trials that did nothing but increase the costs for the clients. This cycle of litigation for the sake of litigation eventually reached a point of diminishing returns, where the legal fees were so high that even a total victory resulted in a net loss for the client. Consider the case study of a fictional 1989 executive named Mark. Mark is going through a divorce and has paid his attorney over $200,000 in 18 months. When Mark finally asks for an accounting of the work, he discovers he has been billed for hundreds of hours of research on legal theories that were never used in court. In 2026, we have automated billing and client portals that allow for real-time oversight, but in 1989, the bill was a black box. Mark's eventual lawsuit against his attorney was part of a wave of litigation that forced the American Bar Association to implement much stricter rules regarding fee transparency and the reasonableness of legal costs. The era of the blank check divorce was coming to an end. The 1980s also saw the rise of the defensive practice of law. Because of the high rate of malpractice suits, attorneys began to spend as much time protecting themselves from their own clients as they did fighting the opposition. They started requiring clients to sign exhaustive waivers and acknowledgement forms for every tactical decision. This created a more sterile, less personal relationship between the lawyer and the client. The attorney was no longer a counselor in the traditional sense, they were a risk manager. This shift signaled the end of the romanticized era of the swashbuckling divorce lawyer, who would do anything to win. By the close of the decade, the industry was becoming more regulated, more cautious, and significantly more bureaucratic. As we look at the wreckage of the late 1980s legal landscape, it becomes clear that the system could not sustain itself. The greed, the ethical shortcuts, and the emotional devastation had created a massive public demand for reform. The 1980s had turned the divorce into a spectacle, a profit center, and a theater of war, but in doing so, it had forgotten the human beings at the center of the conflict. The final year of the decade, 1989, served as a bridge to a very different kind of legal future. The aggressive, media-hungry litigator was about to be challenged by a new philosophy of mediation, collaborative law, and a focus on post-divorce restructuring, rather than pre-divorce destruction. The transition was not just about changing the rules, it was about changing the goal. The 1980s asked, how much can we get? The 1990s would start to ask, how can we move on? But before we can truly understand the legacy of this incredible decade, we have to look at the long-term impact on the American family. The generation of children who grew up in the shadow of these 1980s divorce wars was about to reach adulthood, and their experiences would shape the laws of the 21st century. In the final part of our masterclass, we will pull everything together. We will examine the lasting legacy of the 1980s divorce attorney, the laws that still exist today because of this decade's excess, and the final verdict on whether the professionalization of divorce was a step forward or a catastrophic mistake for American society. We will look at how the tactics of the 80s evolved into the digital age of 2026, and what you need to know to protect yourself in the modern legal environment. The 1980s may be over, but the fire they started in the family courts is still burning. The concluding chapter of this retrospective reveals the true cost of a decade where everything, even family, had a price tag. The price tag placed on the American family during the 1980s did not simply vanish when the decade ended. It became the permanent foundation upon which our modern legal system is built. To understand the true cost, we must look at how the 1980s divorce attorney transformed the very nature of human relationships into a series of quantifiable assets. By 1989, the professionalization of divorce was complete. The legal industry had successfully shifted the perspective of the U.S. public from viewing marriage as a social contract to viewing it as a high-stakes business merger. As we stand here in 2026, the echoes of those 1980 strategies are louder than ever, dictating how we protect our wealth, how we view our careers, and how we negotiate our most intimate boundaries. Historical trends show that the most significant legacy of the 1980s was the institutionalization of the prenuptial agreement. Before 1980, a prenup was often seen as an admission of a lack of faith in the relationship. However, by the end of the decade, the 1980s attorney had successfully rebranded the prenup as an essential tool for fiscal responsibility. Imagine a character named Alex in 2026. Alex is a successful software engineer who is about to get married. Alex's parents went through a brutal, unscripted divorce in 1987, where every asset was fought over in a public courtroom for 3 years. Because of that historical trauma, Alex wouldn't dream of marrying without a comprehensive legal document protecting their intellectual property and retirement accounts. This shift in mindset is the direct result of the 1980s legal community's push to make family law as predictable as corporate law. The step-by-step process of drafting these agreements, identifying separate property, waiving alimony rights, and defining marital growth, was perfected by the elite attorneys of the 80s who realized that the best way to win a divorce was to litigate it before the wedding ever happened. Case studies from the late 80s also reveal the birth of the forensic data mindset. While the 1980s attorney was limited to paper receipts and physical bank ledgers, they developed the logical framework that modern AI-driven forensic tools use in 2026. The 1980s lawyer taught us how to follow the money through layers of corporate shells and offshore accounts. They pioneered the lifestyle audit, where an attorney would compare a spouse's reported income to the square footage of their home and the frequency of their international travel. If you were a high earner in 1988, your attorney's primary job was to build a fortress around your lifestyle. They used the 1986 Tax Reform Act as a roadmap, finding ways to categorize income in ways that minimized its exposure during a property division. This period saw the rise of the specialized valuation expert, a profession that barely existed in 1979 but was a multi-billion-dollar industry by 1989. These experts learned to value things that are invisible, such as the goodwill of a celebrity or the future earning potential of a professional degree. The 1980s also fundamentally changed the physical landscape of the American home by treating it as an equity source rather than a sanctuary. During this decade, attorneys began to use the marital residence as a strategic pawn in a much larger game. Historical trends indicate that the 1980s saw a spike in the use of the deferred sale, where one spouse remained in the home while the other was forced to wait a decade or more to realize their share of the equity. This was a step-by-step legal maneuver designed to balance the best interests of the children with the financial reality of high interest rates. It turned the family home into a long-term investment vehicle that was managed by the court. In 2026, when we see complex real estate settlements involving multiple properties and secondary mortgages, we are seeing the direct evolution of the 1980s attorney's creative use of residential equity to settle alimony disputes. Perhaps the most profound and controversial legacy is the impact on the children of that era. The children who watched their parents participate in the 1980s scorched earth litigation grew up to become the reformers of the 1990s and 2000s. They were the ones who pushed for the collaborative law movement and the widespread use of mediation. They saw firsthand that while their parents' attorneys might have secured a larger percentage of the bank account, the emotional cost was a total bankruptcy of the family unit. This led to a historical trend where the legal profession began to move away from the warrior model toward the problem-solver model. However, even in 2026, the warrior model remains the default for the ultra-wealthy. The tactics developed in the 80s, the invasive discovery, the tactical use of psychological evaluations, and the media-driven reputation destruction, are still the gold standard for high-stakes cases. The 1980s attorney also left us with a legacy of high legal costs that has never truly receded. The professionalization of the industry meant that a simple divorce was no longer possible for the average American. The requirement for experts, the thousands of pages of discovery, and the multi-year litigation timelines became the new normal. This created a justice gap that we are still struggling with in 2026. The 1980s taught the legal profession that there was a massive potential outcome in billable hours if you could make a case complex enough. While this resulted in a more thorough division of assets, it also ensured that for many families, the divorce itself became the single largest expense of their lives, sometimes exceeding the cost of their children's education. To conclude this deep dive, we must recognize that the 1980s divorce attorney was a product of their time, an era of deregulation, wealth obsession, and the pursuit of individual fulfillment at any cost. They were the architects of a system that is simultaneously more fair and more brutal than anything that came before it. They gave us the tools to protect ourselves from financial ruin, but they also gave us the weapons to ruin those we once loved. The historical trends of the 1980s remind us that every legal victory comes with a price, and that price is often paid by the next generation. As you navigate the legal landscape of 2026, remember the lessons of the 80s. Understand that every financial instrument you use, every asset you acquire, and every career move you make has a potential legal consequence in the eyes of a family court. The 1980s attorney proved that nothing is sacred when it comes to the division of property, and that the best defense is a deep understanding of the rules of the game. We have analyzed the rise of the celebrity litigator, the evolution of forensic accounting, the psychological warfare of custody battles, and the global hunt for hidden millions. This masterclass has shown you the blueprint of the modern divorce, a blueprint that was signed, sealed, and delivered in the decade of excess. The fire that was started in the 1980s family courts hasn't burned out. It has simply become the engine that drives our entire domestic legal system. Whether you are looking back in fascination or looking forward in preparation, the 1980s retrospective serves as a stark reminder. In the world of divorce, knowledge is not just power. It is the only real protection you have. The legacy of the 1980s divorce attorney is not found in the law books alone, but in the way we now value our lives, our money, and each other. The decade where family got a price tag may be over, but we are all still living with the bill.